Hi, we'd like to welcome today to everyone today to our webinar, Family Law Matters During a Pandemic. Just a little bit of housekeeping. If you guys haven't used GoToWebinar before, you can dial in by your telephone or you can listen through your computer speakers. We are going to be taking questions, so you'll see there's a questions feature. You can go ahead, type your question right in there. We're going to have a Q&A session at the end. We'll try to get to as many of the questions as we can. If we don't get to your question, we'll definitely make sure that someone from our team follows up with you so that you have an answer to it. So today we have with us Henry Rinder. Henry is a licensed certified public accountant and also a member of the firm. We also have Alex Krisnomowitz, who is also a member of the firm with Smolin. We also have with us today two attorneys from Lesnovich, Marzano, Lesnovich, Okohoin, and Okohoin, LLC. We have Madeline Marzano Lesnovich, who's the firm founder and family law chair. And we also have Francesca Okohoin, who's an attorney and partner at the firm. And with that, I will pass things along to Henry to start moderating today's panel.
Thank you, Amanda. Thank you very much. So today we will discuss actually what's happening in the family area with respect to COVID-19 impact. You know, people perhaps are experiencing cash flow issues. They might have been laid off. Perhaps business owners who are taking cuts in terms of draws, and how is that affecting child support? How is it affecting whatever payments they have in terms of contributions to college, and then what actually is the impact on closely held businesses as it pertains to cash flows and monies, distributions, and other incomes that accrue to the owners who are in some form of obligations, whether it's for spousal support or child support. So I will turn over to Francesca, who will tee off by talking about child support. Next slide, please.
Hi, this is Francesca Okohoin, and as Henry mentioned, I am discussing child support and kind of how we should handle child support during the COVID era. I'm a family law practitioner, as previously mentioned, so that's where my perspective is. Right now, we receive a lot of calls from people questioning what to do about child support if their income has been affected and what they can do in terms of reducing their child support. The main takeaway, my number one point for everyone out there, is that you must continue to pay your child support absent a written agreement with your spouse or a court order. New Jersey does not accept self-help. So simply because you can't pay or it's stressful, do not stop paying at this time. You need to take appropriate action, which I'll set forth below. Traditionally, if someone came in prior to COVID and needed to reduce their support, we would look to see if they had a substantial change in financial circumstances. A lot of people, obviously, through loss of employment, reduction in employment, or sadly being out of work simply because they themselves have COVID, have seen a reduction in their income. So we need to look at this specific change of financial circumstances, whether or not it will allow a party to seek a reduction in child support. New Jersey rules say that the financial circumstance, change your financial circumstances, it cannot be temporary or voluntary. In this case, I don't expect that we're going to see many cases of people voluntarily reducing their employment or leaving their jobs. What we really need to focus is on temporary. The courts want to know whether this is something that's going to continue going forward, or if this is a new, just a brief change, a fleeting change. We don't have any case law right now as to whether the courts are considering COVID to be a temporary situation in order to meet our burden. Truthfully, I don't think anybody knows yet. We don't have enough information on COVID and how long it's going to change people's finances. So I think as a practitioner, and even as a person debating whether or not they can seek to reduce their child support, you have to be honest about your situation. You have to think about really how long do you think your income is going to be affected? Is there relief out there for you? I know we're going to talk about some of the reliefs available to small businesses, or perhaps that your income's been reduced by 20%. Is that really enough because of a furlough? So you really have to be honest. How much has your income been reduced and how much it is affecting it? Do not try to seek to change your child support because your overall wealth has been decreased. The courts are not going to be open to that. And by that, I mean if people are calling to say, my 401k went down, the value of my house went down, my overall wealth went down, I don't foresee that the courts are going to consider reducing child support based off overall wealth. What the courts are really going to look at is what is your actual situation, what is your take home, what is your ability to pay right now, whether it's temporary, and whether or not it's a substantial change in financial situation. Remember, in New Jersey, child support belongs to the children, so the courts are very reluctant to change child support. The children are the last people they want to be harmed by a reduction in child support. So as a practical tip, if you're an attorney listening to this and a client comes in and says, I want to reduce my child support, I would recommend that you really set forth a budget. Look and determine what the expenses are, what your ability to pay is, how it's going to impact your actual finances, and truthfully, whether there's another area you can make up for it. An example is maybe you and your spouse were paying a high amount to extracurricular activities, such as a club soccer or other sports, and maybe that you're not paying that payment anymore. So you might have more freedom in your budget to look for other sources. So those are things to consider. If you meet the criteria, you have to think about what you can do. First and foremost, order to show cause, which is our emergency relief in New Jersey. Very, very unlikely that you're going to be able to change child support through an order to show cause. You have to show irreparable harm, which is our standard, and the courts rarely consider financial issues to be irreparable harm, especially something such as seeking a reduction in child support. So what you would typically do is you would file a motion, but right now the courts are backlogged. They're dealing with absolute emergencies, and I really would not recommend a motion to change child support unless it's a last resort. So in this time of COVID, my recommendations as a practitioner would be to consider ADR, which is alternative dispute resolution. Think about mediation, think about compromises. If you have an attorney, have your attorney speak to your spouse's attorney. Try to figure out a way to resolve this, a way to both figure out what the budget is, what you can pay, how much money is needed without utilizing the court system, which I think is going to be a very lengthy process right now.
Francesca, what about the next slide and the impact on a spousal support, alimony?
So alimony is similar to what I just explained in child support in terms of seeking a reduction. Again, anyone who wants a reduction in alimony has to prove that it can't be temporary or voluntary. In fact, in regard to temporary, our statute says that you have to wait 90 days to apply for a reduction. So if you lose your employment, you would have to wait 90 days before you could even file a motion with the court for a reduction in alimony. We do not know whether COVID's going to relax that or not. COVID's very drastic in this aspect that if people are losing their job, it's not like the pre-COVID days where they could find other employment. So we don't have any case law to say whether that 90 days is going to be relaxed or not. A lot of people believe it might be because of the severity of the situation. But again, my advice is try to work out a compromise, explore other options. Some options would maybe you could reduce the amount you're paying right now, but increase the length of time you're paying. Or if you have assets intact, like a retirement assets or stock accounts, maybe you can do a reduced buyout of alimony. These are just compromises that you might consider before running to court. Because if you run to court to seek a reduction of alimony, right now you would have to wait 90 days for the period. And you're also up against the fact that the courts do not know yet whether or not they're going to consider COVID to be a temporary situation. We all hope that, over 90 days, the periods are going to get better, the economy is going to recover, jobs are going to be back, but we just don't know. And as a practitioner tip, if you're representing someone right now who's coming in to seek alimony, make sure you reread the marital settlement agreement. Whether you wrote the marital settlement agreement or another attorney wrote the marital settlement agreement, read it because you have to check whether alimony is modifiable or not. Because everything I'm talking about, Henry, has to do with alimony as being modifiable. If you have an agreement where it's a bargain for consideration, where the parties agree that alimony is non-modifiable in the future no matter what, it's going to be very difficult, if not impossible, to change and seek a reduction in your alimony based on the finances.
Good point. And as we move on to the next slide, we obviously have a situation going on with colleges and universities shutting down, and there's high uncertainty when and if they will open in this year. And so the question perhaps Madeline, if you could address it. You know, you have obligations in terms of contributions to college education or private schools, and how is that impacting existing agreements and existing obligations? And what is your take on that?
Henry, thank you. This is Madeline Marzano-Lesnovich, and I do want to address the contribution to college expenses. I think we can all agree that no one knows what is going to happen. The courts are trying to sort out not only how to give access to its citizens, but how they themselves can mete out justice in this time of COVID, when people are losing jobs, when everything is changing. The old rules are out the window. This is the norm for now. But both parties in New Jersey have obligations to contribute to their children's college education. The way I see it at this moment, we have three potential scenarios. We have the children who are in college. We have the children who were scheduled to go to college and start in September. And we have those children who are graduating in May. I'm going to discuss these situations from the perspective that COVID is going to continue. We're going to be in the same situation that we are now for at least the next several foreseeable months, and none of us know what's going to really happen in September. So for those children who were in college and compelled to come home and stay, several factors are impacted. One, you've paid for tuition and you may have paid for room and board already. What can you do? My understanding is that schools are not really giving refunds on this, but certainly you as parents should come together. The two of you should act cooperatively in this and call the school and see whether you can leverage what you've paid already towards future expenses, or whether you can get any kind of a refund. Do whatever you can to try and get the cost cut down for the future as well, because you may be experiencing a loss of income now that's going to impact your ability to pay for the next year of college. Also, there are those students who were in college, more than likely in their sophomore, junior, or senior year, who were not using the room and board portion of college, but who had rented an apartment and probably signed a lease for that. You need to be calling those landlords and see whether you can get the lease broken. This is not your child's fault as to what has happened, but you need to find a way to get out of that expense. The third thing that gets impacted is what Francesca was talking about, child support. Because all of a sudden you have a child who has been gone 9 months of the year, who is now home for at least 2, 3, maybe 6 months, maybe longer. And your expenses at your home may have increased. Now, obviously, the shelter expenses will increase, but certainly food, entertainment, clothing, all of that has increased. So parents need to speak to each other realistically about what you can do about that child's particular expenses, because we can't expect that child to go find a part-time job or a full-time job waiting out COVID. That would not be something that we would recommend to anyone. The second scenario I see is the students who were in high school graduating and planning on going to college in the fall. Again, we don't know what's going to happen in the fall. We don't know what schools are going to reopen. I know that several colleges have already said they will not be opening in September. Now is the time to call the financial aid officers of the school that your daughter or son is about to enter in September and see if you can negotiate a better financial aid package. Also, ask the school to extend the deadline, because payments are due for college tuition and for room and board at different times during the year. And certainly you don't want your child to lose their spot in school, but you don't want to be putting money out now, not even knowing if September is going to be a viable operation for college. So I would call the schools, see whether you can get the deadlines extended for payments, see if they'll recalculate costs, see if they'll give you a program that what if school does not open, will there be any reduction in the cost? Same with room and board. So you need to get proactive in this. The third thing is, what about those students who graduate in May? They are really in a stuck situation because it's going to be even more difficult for these students to find a job. But yet, since they graduated, most matrimonial settlement agreements would have provided that child support will end at that time of graduation. But remember, we have to consider whether the child will be financially independent. And I think that a lot of these seniors who are graduating college and who don't have jobs lined up are going to be in a situation where they're not going to be able to afford themselves. If they're still in self-isolation, they are probably still going to be at home with one or both parents. And we need to consider that their support must continue. There is nothing that they can do about it. For those students who had jobs lined up already, more than likely, the companies are not going to have them begin when they originally intended them to begin, because they're not going to take on additional salaries. So maybe those students are going to be furloughed before they even officially start something. A lot would depend upon whether they have a contract of employment or whether they do not have a contract and they're just at-will employees. So all of these things have to be taken into consideration. And I would say the biggest piece of advice is whether you've been cooperative with your co-parent or with the ex-spouse in the past, all of that has to change. You have to be cooperative now. Before, parents were able to really be cooperative, be not cooperative. They might have been forced into being not cooperative. These things have to change right now because we are in a very uncertain time. Most everyone is affected economically. Most children are affected more than economically, emotionally as well, uncertainty as to their future. So we have to look at the college expenses, what we can do about them, whether we can get them reduced, the extra expense that's being put upon a parent because they now have somebody at home that they didn't expect to be at home, and what can you two do in order to help and alleviate the situation. And I would say that the biggest takeaway, if we're looking for takeaways, is get on the phone, start calling the schools, start emailing the schools, and see what you can do to mitigate some of the financial drain on yourselves.
Thank you, Madeline. Excellent observations. Now we're going to move on to something that Alex and I are always involved in, and that's closely held businesses. As we move to the next slide, and needless to say, we do get these calls, and I'm sure Francesca and Madeline get them as well from clients who have obligations because of the previous divorce, and now they call us and say the business is not doing well, and the business and they're asking us to connect them with bankruptcy lawyers. So this is what we are seeing. Alex, what is your takeaway as far as that is concerned with the closely held businesses? And Francesca, of course.
Sure, Henry. So Thank you. So as CPAs, business advisors, experts in marital disputes, the pandemic certainly has us looking at closely held businesses through a new set of lenses. Business owners are obviously faced with new cash flow constraints and meeting their obligations, specifically payroll, especially since the federal government has created the incentive to keep your payroll intact. The windfalls or loans or grants that are out there, such as the Paycheck Protection Program, you hear it referred to as PPP. It comes with policies on the management of those fees and specifically how they can be used and whether they're going to be paid back or not. Henry, you want to touch on some of the federal stimulus guidelines that our clients and businesses are facing?
Yeah, definitely. So as far as, I'll briefly describe it because we've had multiple webinars on this subject, but the Paycheck Protection Program is basically based on an SBA guaranteed loan that can be forgiven if 75% of the loan proceeds is spent on payroll, on gross payroll, with a limit per person of $100,000, and that includes the owners, by the way. That includes the shareholders and the members in the LLCs and so on. It includes sole proprietors. It includes partners in the general partnerships. So I'm simplifying it because I'm moving fast on the topic. It's more complex than that, but the bottom line is you can get a tax-free grant that will cover approximately 2 months of your expenses pertaining to payroll and some of the business expenses such as rent, such as health insurance, interest on your business loans, and similar. So I don't want to spend much more time than that, Alex. Let's go back to the sort of the divorce issues that arise from this.
Oh, sure. Thanks, Henry. That's helpful. That brings us to a business owner's personal cash flow and the possibility or the likely reductions they're facing in compensation and perquisites. And so we have to ask ourselves whether a reduction in a business owner's comp is permanent. Is it temporary? How long will it last? Obviously, we had a quick earlier discussion on support obligations and the ability to pay. But not only are those obligations affected, this concept of pay reduction also impacts a business's equity value. And so we're already seeing in business valuations these issues on closely held entities. Some of the things we have to consider, some of the things that are being impacted are changes to a business's risk portfolio, troughs or dramatic decreases in sales and collections. Consideration down the road, is an entity going to have a full recovery versus complete devastation? We're looking closely at sales and cost of goods sold and historical cycles. Obviously, market conditions, we can all turn on the TV and see the seesaw that's going on in the markets. But aside from that, we're having to look very closely at industry conditions and see what a subject entity's industry looks like, not only now, but next month, next year, 5 years down the road. Along with that is heavy consideration of an entity's competition. Are the entity's competitors better fortified, come out of a pandemic in a sprint, or are those competitors dropping out of the landscape? Some entities are going to have a distinct advantage when this is all over, while others may not survive. All these matters have to be carefully considered, certainly on a case-by-case basis. We're obviously trying to provide fair and unbiased opinions to a trier of fact. Another relevant and heavy impactful issue is the concept of a subsequent event. We all know bad things are going to happen in response to COVID-19. Bad things have already happened to businesses. But at a certain valuation date, we consider whether something that may have already happened, because we're performing a valuation now, and the valuation date may have been in the past. So Was such event predictable? Was it known or knowable? Is an event that's going to happen down the road known or knowable? Maybe a huge sale that looks like a win right now, and it's sitting in your AR, and all of a sudden, months down the road, that customer goes belly up and isn't able to meet your receivable. Was that known or knowable in response to COVID-19? As appraisers of businesses, we have to consider that, and whether those market conditions, those financial performances, are they relevant at the valuation date, and does the subsequent event affect the value, your conclusion of value? You can certainly mention a subsequent event in your report as an FYI, but you have to be very careful as to whether you state if it affects your conclusion of value or not. Henry, anything on subsequent events from your perspective?
Well, I think you went over a lot of excellent points because, frankly, from our perspective, it's not just the business itself, the operation of the business that matters, but also the health, the financial health of the customer base, the financial health and condition of the team. So all of that is going to play into our evaluations of closely held businesses right now. And there's significant risk on both ends, and there's a significant uncertainty on both ends. Francesca, what is your perspective on it?
Henry, my perspective on what specifically?
In other words, in terms of like the, clients that want you to file for a divorce now, and they basically come to you and say, look, I think my business is hurting. I think the value is lower. This is a good time for me to get a divorce. Do you have those cases come through like that?
We do. I'm very hesitant in general to file for divorce right now. Everything that's coming to me that's an initial filing, we are really trying to work through beforehand because I don't think that this is a time to file for a course. But in terms of somebody saying that their business is low, I think it goes back to what I was initially saying about whether it's temporary or not. The court we do not have economic case law to determine whether this is temporary. So whether the court considers that the business, like Alex said, some businesses are going to be hurt forever, or some businesses are going to, be okay in a couple months. I don't think we have enough case law as to determine how long of a period the court's going to look at in terms of the impact of COVID on income and businesses.
So we are getting pretty close to the end of the webinar. We have a few minutes. So Amanda, do we have any questions from the audience?
Yeah, so one of the questions that came up a couple of times, people were wondering if they do kind of work with the other parent to make adjustments and compromises on either, the child's custody amount or shared custody. If they agree to that temporarily, what will that look like in the future? Like, will it affect their ability to enforce the agreement that they had previously?
This is Madeline. I've been recommending to clients who have changed their parenting schedule or changed the support that they put in writing, this will not affect. I am willing to have you have 50% of the time with our children during this period of time if you agree, and only if you agree, that this will not be the basis for a subsequent modification of our parenting time. I've been having my clients do that both in terms of parenting schedules and in terms of support.
Amanda, any more questions?
Yeah, I think it's similarly along those lines, and it sounds like it'll answer it. People were wondering because, children in maybe at-risk households, with the children going back and forth between the homes, if they were to do extended custody agreements, so maybe change it out to 3 weeks instead of, just every week or every weekend, would that impact the child support, or would that be on a case-by-case basis?
I'll answer. It's Francesca. It would be more on a case-by-case business, but again, I think it would be considered a temporary change. So if you're talking about a change that's going to last 1 month, 2 months, 3 months, that's not going to be enough to change child support. You would really have to look at a long-term change to the parenting time schedule in order for child support to be affected.
So we are coming to the end of the webinar, and as Amanda suggested at the onset, that if you put your questions in, our panelists will answer those questions. They will email the answers to you. So we make the best effort to make sure that all questions are answered. But we surely cannot answer them all during this limited time. So I wanted to thank Madeline and Francesca and Alex for joining us today. I wanted to thank Amanda for doing a fabulous job of hosting us on this webinar, and thank the audience for attending. Thank you very much.
Thank you.
Thank you, Henry.
Thank you. My pleasure.
Everyone.